All right. Good morning. Happy Friday. How's everyone doing today? Hey, it's the Mother's Day weekend for all the beautiful moms. Early happy Mother's Day. So, we're going to be discussing today mediation, part of the initial process that allows the consumer, if there's a dispute, how to navigate a mediation process, right? And the beautiful thing is, we as real estate professionals are not necessarily involved in the mediation. Typically, a certified mediator will step in, hear both sides of the situation, and the common ground is to get them to come to an agreement, right? That's the initial process of a mediation. So for today's training, we're going to dive into the understanding of a dispute resolution under the California Residential Purchase Agreement, better known as the RPA. All right, so let's continue. And let me get this out of the way here. All right, so what this course will teach us, right? The course is designed to equip real estate professionals with the practical knowledge and tools to navigate a conflict with confidence and with certainty, right? I know that when there's a mediation, it's never a fun thing to be involved in. This is where leadership will help navigate that, right? If there's a dispute regarding, the buyer, the seller. But you got to understand how the mediation process. So learn how the mediation works through the purchase agreement, manage the dispute, right? Navigating emotional charge transaction professionally and resolve a conflict, right? Because when it's heated and there's a conflict, that's where it gets escalated, right? Because there's not a meeting of the mind. And then obviously, how do you reduce liability, right? Protect all parties as part of the understanding and really not to cross the boundaries. Remember, this is a disclaimer. You are not licensed attorneys. Okay. So don't act like an attorney. If there's a dispute, you escalate it to leadership. Let leadership help navigate that with you, right? Now, most situations you can diffuse, and how you diffuse it is the more deals you close, the better understanding and how to take it to the finish line right at the end of the day. But when there is a conflict and there's uncertainty of what's going to happen, then we can always escalate it, to speak with an attorney, and we can navigate it in two ways. We can have the consumer talk to their own legal counsel, or we have, as part of the package deal, risk management, right? RERM, that will give you an opportunity to speak with an attorney to kind of get a guidance and support and what best practice to get us to the finish line, right? The goal is to get us to close the deal. Okay. But these are some of the stuff that we're going to be talking about today. So, why does mediation really matter? Most transactions do not fail because of the market. They fail because communication breaks down. That's typically. I'm dealing right now with a situation. We represent the buyer. The buyer submitted an offer. Our agent navigated the due diligence process. We asked for a current HOA documentation. The seller and the listing agent gave us a HOA document from 2 or 3 years ago. The agent asked, "Hey, can you provide us with the most current HOA bylaws, CCNRs, financials?" And they gave us old documentation. So our agent went and spoke with the HOA department, requested copies of the current stuff. And to our surprise, there was a lot of discrepancies what the current owner provided and what the HOA provided. That's where there was kind of a pause and to really understand the ins and outs of what particulars was happening with this complex. So the buyer and the buyer agent put a request of repairs because there were some things that were not divulged, not disclosed to the buyer. So there was a little bit of a hesitation. Well, the listing agent and the sellers were pressing hard, pushing hard to have the buyer release all contingencies because they got to that point where it was time for all contingencies. The buyer and buyer agent came back and says, look, we have our due diligence because this is new material fact. We want to understand what else we're not seeing here. So we're asking the necessary time frame to do our investigations. The listing agent and seller says no. They send a notice to perform, and now they're threatened to cancel. That's where I came in. The agent reached out and says, hey, we have a dispute. We're not seeing eye to eye, and therefore we're asking for guidance and support. I listened to both sides of the case, from the buyer's agent, from the listing agent, because we also had a conference call with the listing agent. So I get an understanding and a clarity. My goal was, I'm not here to side with anyone. That's not my goal. My goal is to be neutral and help push the buyer and the seller to the finish line. So after back and forth, we thought we had a resolution and everything seemed right. The listing agent requested for the buyer agent to send a new request of repair number 4 because it was back and forth 1, 2, 3, and 4. And we got the buyer to agree and sign, send it over to the listing agent. And within 4 hours, the listing agent says that the seller wants to cancel. And it's like, what happened? I thought we were good. I know there was a dispute. There was not a meeting of the mind, but there's needs to be some resolution other than just cancel. We're there. Loan docs were already in escrow. So it's kind of a compromised position. The seller is very adamant, does not want to continue, and we're kind of on a standby. So the next step is going through a mediation process because the buyer wants the property. The seller doesn't want to sell the property. And so there's kind of a gridlock right now, and there's really not much I can do. I can't force the seller to do the right thing, even though on contract, we're doing everything correct. They just don't see it. That's where sometimes the breakdown happens, right? Now, the listing agent said, well, we were trying to get a hold of the agent, and it took several days before we got a response. That delayed the process. This is why the seller got a bad taste. And I told the listing agent, I says, that doesn't really matter, okay? And there was reasons behind this is because you're so aggressive that the agent just decided to stop any communication for the time being until I intervened and stepped in. And I've been in communications consistently. I respond to text messages, emails, and phone calls as well. So that's kind of where we're at right now. I don't know what the outcome is, but I can tell you that the buyer still wants this property, but the seller is making it very difficult to proceed. So it's going to be a continuous, and I'll let you know. All right, the reality of a real estate dispute, right? Real estate transactions are among the most emotional loaded financial events in a person's life. Would you agree or disagree? Yeah, 100%. This is sometimes one of the biggest financial decisions for someone, especially a first-time home buyer. It can be a very grueling experience, very stressful experience, and the uncertainty, right? And anything that doesn't look good on a home inspection report, they're ready to cancel because they get cold feet, right? And that can be the essence of a situation that can happen, right? So what every transaction involves is significant sums of money, obviously, compressed timelines and deadline. Remember, pressure, right? If you have a certain contingency removal, right, which is 17 days, And now you counter back and forth. And instead of 17 days, now you're doing a 10-day or an 8-day or a 7-day to release a contingency. Pressure's on the buyer to perform, right? And if the buyer truly wants this property, before you know it, it's like it's already the 6th day on a 7-day contingency removal. That's a lot of pressure that the buyer may have. But the beautiful thing is, if you understand how the contracts work, right? If you know you're not going to meet those expectations, communicate immediately, let the opposing agent know that there may be a delay on our part, and we're asking for an extension of time to do what we need to do. It's just an ask. Does the seller have to give you the extension? No. Okay, because it was already agreed upon in the very beginning of the terms, price, and condition, right? But the essence is if you don't feel compelled that you can do what you need to do, ask for the extension sooner than later. Make sense? How clients can behave under pressure, right? Let's just be for what it is, right? Who likes to be in pressure? I don't think any of us like to be in pressure, right? Because what happens is you become defensive or combative. I see it quite often. React emotionally rather than rationally, right? Distrust to the agent or the other party, right? They start thinking they're lying to us. They're not being truthful. Something they're not telling us, and it's making me a little uncomfortable, right? All of these emotional things come into your head, and you're not kind of focused and thinking, right? And all of this is part of the pressure that a consumer may have, right? So our job is to help navigate that, asking the right questions and being a good listener too will definitely help navigate this process, right? When communication deteriorates, disputes escalate quickly, and the cost of escalation falls into everyone involved, right? So, as much as we like all of our deals to close smoothly, right? We want them to close smoothly. You're going to have hiccups. You're going to have bumps down the process, right? It's our job and it's our responsibility to be able to navigate that, right? And there's only so much that you can do at the end of the day, right? Sometimes it's out of your hand. Once it's going 100 miles, it's going to be hard to stop. And sometimes you just got to let it be, right? But also keep in mind that when it's stemming to be something bigger, don't wait till the last minute. Bring leadership involved. Leadership is their job is to diffuse, de-escalate, and ultimately to avoid a litigation or a dispute, right? And once you get leadership involved, then we tag team it together so you don't feel that you're by yourself. That's one of the most important elements that I can tell you today is if you know something is already going sideways, bring leadership involved. Our job is to help navigate it. And if we don't have the answer, then we escalate it and we get you the answer that you need. Make sense? All right. So what happens when there is a dispute, right? So let's talk a little bit about that, right? So part of our process is early intervention, right? So the sooner you can stop the fire before it blows up, right? Because once the fire goes, it's going to be hard. It's like a forest fire, right? It starts small, and if you can eliminate it before it gets too crazy, then it's easier to navigate that, right? Remember, our job is to be a problem solver, and not to point fingers and blame other people. Be neutral in your conversations. Even though they're barking like a dog at you, rah, 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 keep your composure, okay? And just get to the stem of the situation. Because sometimes they'll go 100 miles, talk about this, talk about all of this, but they don't talk of the core of the situation. The ignite, the fire that started is where you need to get to. And that's where good real estate professionals know how to tackle on those issues. Because they'll be like listening to all this all this fire here, and it's like, okay, what do I need to do to neutralize the situation before it gets even worse, right? Because once they start threatening about lawsuits, and just last week I was dealing with one of our agents who represents the buyer, the seller, and she's on a dual transaction. She is selling her property. She is buying a property. He's the listing agent, but he's also the buyer agent as well. There's a lot of moving parts regarding that. And it's difficult because the buyer, the owner, seller got so upset. And immediately she started using language that I knew it's going left field. Okay. And I cannot say don't do it, right? Because we always tell all of our agents, you know, please speak with your attorney. They have a right and an obligation to do so. Okay. Especially if it's going sideways, we always encourage them, why don't you seek and speak with legal, right? And get an understanding of what your position. It's not our job to interpret that. It's really them to seek legal advice. Remember, emotional reactions, right? Remember, keep the composure, be a good listener. Don't get entrenched in the fire of the chaos dispute. Find an avenue of solution before it becomes a legal situation, right? And if it does go to a legal situation, what is your best policy here, right? Documentation, making sure that all of the emails, all of your text message, all of your voice message, you keep them because that's your proof, that's your evidence. Remember, everything has a timeline of events that occurred, right? It's no difference than what I think like an earthquake, right? The epicenter of an earthquake may be, 7.2, right? And it started, let's say, in the valley. But by the time it hits San Diego, you think that in San Diego it's going to be 7.5? No, it's going to be probably less, right? It started here, but the waves will eventually hit over here, right? So that's kind of the same situation when it comes to these positions, right? Is that the sooner that you can take and intervene in a situation, diffuse it, or find an avenue of solution, the faster the damage can occur, right? Because once there's damage, then that's when we start seeing a lot of attorney talk, and that's what we don't want. All right. Progression from a productive negotiations to legal warfare is exactly why the mediation process exists in the RPA to interpret the cycle before it becomes a financial devastation. Right. Remember, mediation. Just so you're clear, um, is really someone that's a referee. Put it that way. You're in a boxing match, right? And you got two components that are ready to duke it out, right? The referee is there to navigate and make sure that everything is within par, right? But in real estate, it takes a little bit more. A mediator's number one core is to come to a resolution. Okay. And whatever resolution that is, if it's for the buyer, if it's for the seller, or if it's both, that's where a mediator's position is to finish and conclude and everyone is happy. Okay. Or may not be happy, but they come to a resolution. That's the whole purpose of a mediation. So, what is mediation? So let's dive into the core definition, right? So mediation is a structured volunteer process in which a neutral third party, the mediator, facilitates negotiations between disputing parties to help them reach a mutual acceptance resolution. The mediator's role is one thing, is not to be a judge. They do not issue rulings. make decisions, or force any outcome. The parties themselves retain full control over the resolution. And that's so true. A mediator is not a judge, doesn't have the hammer and says, you're the winning to this particular transaction. No, that doesn't work. A mediator's core goal is, as I mentioned, they're right in the middle, listening to the buyer side, listening to the seller side, and helping them all come to an agreement. Okay. It's no difference than a parent to a child. Okay. We deal with a lot of negotiations with our kids growing up, right? When we ask them, did you clean your room? I will do it. 2 hours later, you go to their room and their room is still dirty. I asked you to clean your room. Yes, Dad. Yes, Mom. I will do it. I'll do it right now. An hour later, you go back and it's still not done, right? Now you raise that bar where now you're a little upset, right? And didn't I tell you to clean your room? I told you this about a couple hours ago and your room is still dirty. I'll do it right now, right? And then they start doing it, and then you come back an hour and their room is still not done, but they're still looking like they're doing, right? Then you have to put the hammer and says, look, stop. I asked you multiple times, why isn't this room done, right? So, you know, this is kind of like the negotiations that I see happening in a real estate transaction. It's a dispute, right? It starts with, yes, we'll take care of the request of repairs, but then you look at your request of repairs and what the seller did and what the buyer wanted, it doesn't match. And now you have a dispute, right? And I said, well, this is the agreement. You mentioned that you would accept our terms, that you would fix this, give us credit for this, and do a price reduction as an example. You didn't fix these items as part of our agreement. Well, I give you credit and I give you a price reduction. I get it, but you also told us you were going to fix ABC. Okay. And that's where it escalates. Well, I'm not going to do it. Well, okay. If you don't want to do it, then we have to either try to mediate this, get our leadership involved, and come to a final resolution, right? So, what the mediator does not do is this: does not act as a judge or an arbitrator. Okay, does not make binding rulings, does not decide who wins or who loses, does not force a settlement on any party. What the mediator does do is help parties understand their risk, evaluate strong and weakness of each position. As a mediator, listen, Miss Bernice, I understand how upset you are, but look at the contract. The contract stipulates that you agreed to do this. My concern is that the opposing party will escalate this. I want you to understand your position. Now, I'm under no obligation by forcing you, but I want you to look at the black and white of this. Okay. And whatever direction you want, you let me know. Then you say what you want, and then I take it to the opposing party and just trying to resolute, right? Try to come to an agreement. It could be with a starting of, I won $25,000. I feel that I'm damaged, right? And that may be the starting point of a negotiations. Now, as I stated, the mediator's position is not to be the judge, okay? It's not to rule on anything. It's for the mediator to help push a resolution, push to a resolution, right? You give me what you want, I'm going to send it to them. They're going to give me what they want, I'm going to bring it back. This is what they told me. What do you think? I disagree with that. I don't want to, but let's do this. I'm in another situation on a buyer representation agreement. One of our agents have had an exclusive BRBC signed by the buyer, was working with this buyer, and then all of a sudden, within a month and a half, went radio silent. And the agent kept constantly going and calling and trying to meet, and they just lost communication. Well, during the time when everything was fine, the agent and the buyer did see some properties. And I want to say that it might have been like 5 or 7 properties that they I looked at before all communication stopped. The agent, maybe 4 or 5 months later, happened to be searching the MLS, and she remembered this particular property that she showed the buyer. And to her surprise, when she did a little bit of digging and background, the buyer that was her client bought the property, but did not use the agent. But she had a buyer's representation agreement within the timeline during this particular transaction. So she reaches out to us and says, help, do I have a case? And I said, absolutely. Yeah, the buyer breached the contract. This is why it's important for you to understand that if you have the proper paperwork, you have every rights. This is the reason you have these documents to protect you, because I understand the time, effort, and energy that we put into navigating and working with clients. And for the client to think it's okay to go with someone else when you were heavily involved, that's not right. So I ended up preparing a very aggressive email on her behalf. I sent it over to the buyer slash now homeowner. No response. I thought, interesting. I didn't get it. So we kind of tabled it and left it alone. And then I resurfaced the conversation with the agent, and then I ended up sending a second email, and boom, it got hooked. I got a response from the buyer saying, I disagree with all this. She was not involved. And this is what proper documentation is vital, folks. Vital. We had everything, text message, emails, BRBC, the documentation that showed that she was also involved in showing her as that property that he ended up buying with the listing agent. Okay. And thought he would get a better deal going with the listing agent than through her. So he finally reached out and he sent me this very lengthy detail. He used ChatGPT all over the place. You can tell that it was ChatGPT, and he portrayed himself like he knew what he was talking about because he used ChatGPT. And because I understand the contracts, I deflected everything, I dissected everything, and then I put a proposal back at him. And ultimately, he says, "Well," and this was a almost $30,000 commission going to her that she lost. Okay, just to let you know, 30,000. So after being able to diffuse the situation, he comes back and he only emails me directly, and he says, "Look, I don't plead guilty to anything, but I'm gonna throw a $7,000 to you." Yeah, $7,000. Now, to me, that's a win. That's $7,000 that is like, wow, we at least got something better than nothing. So I proposed it and I told the agent, I says, hey, I got a counter, or excuse me, I got an offer. The buyer's willing to pay you $7,000. What would you like to do? Well, Simon, I did all this. She gave me a list of laundry. She was upset, which I understand. Almost 30,000, 7,000. It's negotiations. She goes, let's start at 18,000 and see where it goes. With the goal that I can settle at 15. I says, okay. I mean, the only thing we can do is just give it a shot, right? So I sent another email saying, we decline your offer. We appreciate the offer, but we're too far off. To avoid any escalation, which we have every right, and we have all the evidence, and I provided everything to him on the original email. He went radio silence, but we gave him a timeline to response. Then he came back and said, and I think it was a lot less. My apology. I think it started at a lot less, like 4,000, and then it went up to like 7,000. So in speaking with the agent, we came to a conclusion and just trying to finalize it. So she says, look, okay, let's not do 18, but let's see if we can do a little less. And I believe it's like $14,000 and see where it goes. So I says, not a problem. I sent out the email and we're still impending. I don't know yet where we stand, but I'll let you know the outcome. The moral of the story is that, if as long as you have your position, you have your documentation in place, then it makes it a whole lot easier for me to help you. It's situations where you don't have any proof, anything documented, anything for me to use as a ground to now push it to where we need to go. And that's why it's very important that when you're dealing with buyers, dealing with sellers, that you document everything. That makes it a whole lot easier. Because the last thing we don't want to go through a mediation process. If we can resolve it before it escalates, because once in a mediation, now there's additional money that needs to be involved to go through a mediation process. So just keep that in mind. All right, I think we talked about mediators does do, right? How parties understand their risk, evaluate strengths, explore various settlement options, and reduce emotional escalation in the room. So the goal of the mediation is really simple. Mediators is not about providing who is right. It's about resolving a dispute efficiently before both sides spend more money, time, and emotional energy than the dispute is worth. Reframe arguments, right? The mediator's responsibility is to diffuse emotional accusation as part of the process, right? And just navigate a workable solution. Identifying the weakness, right? In private conversations, the mediator can surface vulnerable positions with each party to kind of find the unwilling to acknowledge something that we can use as a position, right? To be able to help navigate the outcome. And then the reality test expectations, right? Parties often overestimate their case, right? Sometimes you'll hear like blah, 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 blah. And then I say, stop. Tell me what the real reason we're having this conversation. Oh, it's because of this. So we just spend 10 minutes talking about something totally different because they got to take me to this roller coaster ride before they get to the core because they are trying to explain to me what led them to where we're at now. Does that make sense? So instead is let's just get to the core of the situation. I don't need all of the additional stuff. I just need to know how we ended up here, like the spark that started this fire, right? That's kind of the stem of what we're trying to get. And then obviously keep the progress moving, right? Mediators keep negotiating productive in the focus, preventing the conversations from collapsing, right? The more we can speak, right? Because once someone stops, I'm mad. I'm not going to say anymore. Then that's pretty much the end. We don't have a conclusion. But the more we can have the people talk, the more people will get exhausted and will now want to just come to a resolution or a settlement. Okay. So think about it from that perspective. But why am I teaching this course? Okay. Not for you to be expert mediators, but to understand how that happens if you have to go through a mediation. So now you have an understanding. Oh, I remember when Simon was teaching class on mediation and how that works, right? And what the core of what their responsibility is and how they navigate that. Okay. Just so you understand. And you may be part of it too. And I would encourage you, even though you're neutral. Okay. Because this is not a dispute between you. This is a dispute between the principals. Does that make sense? Okay. Why mediation works, the advantage, right? Fast resolution, less expensive, completely private, preserves relationships, right? So time of the essence. As soon as a mediation, excuse me, as soon as a dispute happens, immediately you revert back to the contract. Look, here are some of the options that you have. I'm also going to share a website that you can have your clients go through, the California Association of Realtors Mediation Dispute website, where you're going to be able to direct them to that website. They fill out everything and you're done. So the mediation under the California Association of Realtors RPA Residential Purchase Agreement, right? So the California Residential Purchase Agreement contains one of the most consequential clauses in the entire contract, the mandatory mediation provision, understanding understanding it that's optional for any professional working with a buyer or seller in California. So this is not just for one side, this is for both sides. Okay, so it's for anyone. If you represent the buyer, represent the seller, it is for that purpose, right? So, what does the RPA require? The core obligation before pursuing any litigation or arbitration, the buyer and the sellers are contractually required to attempt mediation. That's what it says. Before you think about doing this, why don't we try to get a mediation involved, right? Because the minute that you get an attorney, the attorney is going to charge you $500 or a retainer of $5,000 every time you call them. A minute is their charge. So to avoid costly expenses, the best resolution is to go through a mediation, which I believe the mediation, and don't quote me on this, I think it's $250 or $500 a side. That's it. And they'll allow, I believe, 2 to 5 hours of mediation. You should be able to get everything resolved within that time frame. The longest mediation I've been involved was 10 hours. It was in downtown Los Angeles on one of the high rises, and very, very beautiful building. The conference, they had snacks, they had everything because they know we're going to be there for hours. I didn't think I was going to be there for hours. I thought a couple hours done, we're out. Back and forth, back and forth. And it was just kind of like, are they? And these were attorneys that were mediating. So there was two attorneys, uh, one that represented the our agent's clients, and then the other client's attorney too. And they love to drag it. Oh my gosh! I thought, man, I can get to this faster than you attorneys. But we ended up, and we still couldn't come to an agreement. Believe it or not, couldn't come to an agreement.
Do you sit together or do they go like from room to room?
Separate. Yeah. Yeah, because if you get it in front, yeah, I mean, I get it. But they believe that having two people that are already upset at one another is just like a cat and dog fight.
Yeah.
You're not going to get any resolutions. And I'll share another story. Allegheny, if you guys know, Allegheny many, many years ago had a client and they were going through a divorce. And the husband was pissed off. He was hard nosed. He was upset. He was upset that he was getting a divorce. He didn't want to get a divorce. But the wife was done. So Al had went on vacation, and at the time, when his father and the team were still here, um, they asked me if I can step in and help a conversation. The two sellers were going to come, but they're not in good standing. They're not even living together anymore. So I says, not a problem. And this is before we had the two conference room. We only had the conference room on the right. The conference room that we have on the left side, like if you're coming in, this conference room was in a conference room. That was an office. So there was no door there. It was just a wall. You had to go around to that office. So we made those two as a conference room. So the wife came early. I put her in one of the conference room. And then the other, let me see, I'm trying to think. I don't know if you know Jim Sapula's office. That used to be the other conference room, which is behind the wall in the main entrance. That used to be the second conference room. So the wife came, and then I put her. No, the husband came, and I put him on the back room. And I introduced myself, and he says, "Why am I in this conference room? Where's my wife? I want to be with my wife." And he was pissed, and you can see he was like a shrimp. He was pissed. And it says, the reason I'm not allowing this is because of this. Until you can hold your composure and lower your voice, because he was loud. I says, I'm not going to allow you guys to be in the same room. And on top of it, your wife or ex-wife doesn't want to. So I have to also protect her as well. Fine. So he sits down. I don't, it was so many years, and Al can probably tell you the story, but it was just a funny thing, you know. And finally, she was okay. She goes, I think it's best if we are in here together. So he was pissed, and as soon as he walks in, he sits down. Literally, I kid you not. I just saw like his emotions just come out. And he looked at her because he hadn't looked at her for months. And he got emotional, like he was about to cry. And then he was like a puppy, super quiet, super nice, like his demeanor. Yeah, like thousands pounds of weight just came off when he saw his wife. Because remember, he didn't want to get a divorce. And she was stern and firm and professional. And she was dumb because he was crazy. And I could see it. Yeah. Now I don't remember really the reason, but I think they needed to sign off or agree because they were selling their property. And that was it. He was still living in the property she had already left months earlier. But they needed to come in agreement because this was delaying the process, but they couldn't agree. They were bumping heads. Well, I thought I had it under control. And something she said that spark, he gets up, he pounds the table, and he starts cussing, I am out. And he walked out. We looked at each other because it was one of the team members, the wife, me, and the husband. We looked at each other. It's like, what just happened? What happened? Yeah, he left pissed. And she says, and she apologized. I am so sorry that all this happened. I had a feeling this was going to happen. I thought maybe if we come to a neutral location and you guys involved, that he would put some sense that we need to get this done. So it's behind us. He gets his share, I get my share, and we're done. We never have to see one another. And I says, yeah, I am so sorry. I thought I had it under control. I had a feeling as soon as you guys got together, this was going to happen, but I kept it because you asked me that you were okay. But see, this is what happened. So to answer your question, this is why we don't want to put them together, because it may start off pleasant, but then it can erupt and be a disaster. So it's best to put them in different rooms, and the mediator's job is just to go back and forth. That's it. Yeah. Okay. So this is one of the most misunderstanding and financial dangerous provision in the RPA. Every agent must know it cold. So basically, know the documentation and the verbiage, right? All right, so attorney fee consequences in a real example, right? The stake of bypassing mediations are not really a good thing to do. Here's how it plays out in the practical elements, right? Buyer files a suit or a lawsuit against the seller. Buyer's upset about a undisclosed defect and skips mediation process directly to litigation. Buyer wins the case. After an 18-month legal battle, the court finds in the buyer's favor on the merits of the claim. The court reviews mediation compliance. The court determines that the buyer failed to attempt mediation as required under the RPA. This is why, ladies and gentlemen, I encourage you to make sure, because that you have to initial. Okay, it doesn't allow, if you use like DocuSign, it doesn't allow you to automatically. You have to manually make sure that the buyer signs off and the seller sign off. And if they don't sign it, that's a red flag. Okay, because again, this can happen, right? So the court determines that the buyer failed to attempt mediation as the required part of the RPA, right? So buyer absorbs 90,000 in legal fees, right? Despite winning, the buyer is denied attorney fees recovery. Their 90,000 in legal costs remains entirely their own responsibility because they fail to go through a mediation process. So this is why you need to understand winning in court does not protect you from attorney fee consequences. You may win the settlement, but let's say here's my bill from the attorney, and attorneys are charging 450 to 5 to 600. I spoke with an attorney, and he says, "I'm a Beverly Hills attorney." I says, "Well, what's your hourly rate?" $750 an hour. I says, "Whoa, that's a lot of money. You must be one really good attorney." So you see where this goes, and that can happen. Okay. So exceptions to the mediation requirements. Okay. Not every dispute requires mediation before proceeding. Certain circumstances allow parties to bypass the mediation step without triggering the attorney fee penalty, right? Small claims court, right? So this disputes involving claims under, and I think that amount has gone up. I'm not sure, but I think so, or it may still be at $10,000. Maybe the file directly with small claims. So if it's a dispute, the way I see it is, look, if the seller and the buyer cannot come to an agreement, buyer, you have every right to file a lawsuit against the seller after the deal closes. Okay. Let's just say, for example, that, the seller agreed, uh, agreed to replace, say, the HVAC as an example, right, as part of the agreement. But then the seller got pissed because the appraised value came in a lot less and he needed to sell the property. So he says, "I'm not going to do the HAC after all, because now I lost $25,000 that I would have got to pay for your HVAC," right? So he decides not to replace the HVAC, right? While the buyer has to make that ultimate decision because, again, it's their responsibility. But part of the guidance is speak with an attorney to guide you. But here are some of the options. You can always go to small claims. I believe that it's up to $10,000 that you can file a lawsuit against any other party. And I think you have a very good place. It's in black and white. You have the seller's signature saying he agreed to replace the HVAC. They didn't. You go to court. The judge would make the ultimate decision. Boom. In favor of the buyer. And there you go. Now you have a lien or documentations that you can go after the seller. Any questions so far on that? Okay. Let's see. Do we have any questions on chat? I love that. We pay for the attorney's therapy. Yeah, that's right, Teresa. Emergency court action situations required immediate intervention, such as obtaining a injunction, restraining order. I mean, that's if it's super, super crazy. But again, most of them can be resolved through mediation. Attorney fees and litigation risk. The bigger danger is often not the dispute itself, it's the paper trail created by poor communications before anyone calls a lawyer, right? So let's kind of dive into that quickly. And I know we're running out of time. This is being recorded, so you'll be able to have this recording as part of the KW Shares YouTube. How agents create liability without knowing it, right? Poor communication habit. So danger statements agents make. You're definitely win this. The seller has absolutely no case. I can guarantee you'll get your deposit back. Okay. Don't worry about it. They cannot do anything. These statements constitute unauthorized legal advice and creates direct exposure for agents in the brokerage. So make sure you're watching what you say, because all of this can be used against you, folks. Okay. And for people on Zoom too, please take a picture of this and be mindful, because you don't know if you're being recorded, right? You just don't know. They should disclose, hey, this conversation is recorded, but some people don't. I caught so many people trying to record me, And I asked first and foremost, is this being recorded? Okay. And the reason I say that is because if they use that against me, I can say part of the conversation that I asked if they were recording, they said no. And then I find out every detail that I said is like, wait a minute, how did they remember all that? They had to record it, right? And then I can dispute that, right, as part of the conversation. Not that I'm opposed to have something recorded, because I think recording is ideal. I think it's important. But as long as you just let the party say, is it okay if we record this conversation so later if I have any questions, right? This is why attorneys always have recorders. They have their yellow paper pads, right? And they just write. And now with ChatGPT, even I went to the doctors not too long ago. The doctor that was evaluating me, he said, is it okay for me to record this session? And I says, yeah, I have no problem. She says, the reason I record it is because I use a AI platform that records and gives me a breakdown of our conversation and, the diagnostics and what treatments and medication. And she doesn't have to do anything. Like in the past, she would have to write these reports as a doctor. Now everything is dictated, and then AI handles everything, and boom, it populates a report. I mean, it's great. It enhances our position, right? But I think, like she said, is give me the permission to record our session, is what we're saying. Better professional language. You may want to consult with a legal counsel regarding your options. I can document what occurred. Your attorney can advise on next steps. Let's make sure we have everything in writing before we respond. The risk management rule: stay factual, stay neutral, avoid legal conclusions, document every communication carefully and promptly. When in doubt, escalate it to your broker or RERN. Okay. Okay. Where can consumers find a mediator? Okay, so let's dive into the actual, and it is on your purchase agreement. There is language that says where you can find it, right? So finding the right mediator, right? Card Dispute Resolution Center. The RPA specifically references the dispute resolution for real estate as and here's the website, consumermediation.org. Consumermediation.org as the preferred provider unless parties mutually agree on another mediator. Okay. Local associations often maintain referral list, a panel of mediators as well. So even the South Bay Association, Pacific Association of Realtors, the Inglewood, and a lot of your boards may also have internal mediators that work for them as well. Attorneys and mediation websites do some research too. You don't necessarily have to use CAR's mediators, but they're one of the best because all they do is real estate disputes regarding CAR forms. This is why they're elected as the preference, but it's not required. These are some of the options you have. And then California Consumer Programs, California Department of Consumer Affairs, and some district attorney consumer programs offer mediation resources as well. Oh, gosh. Stop. Here we go. So understanding the mediation cost. One of the most important conversations agents must have with their clients is setting realistic expectations about mediation costs. Many consumers assume it's free. It's not free, folks. Okay. If someone is going to step in to help navigate this, they're going to want to be paid for time to put a resolution, time to listen to the case and finalize with a settlement or an agreement, right? No one works for free. Okay. So typical cost structure, most mediators charge hourly rates. CAR mediators typically offer a reduced rate for the first 2 hours. A non-refundable filing fee is generally required upfront. After the initial discount period, mediators charge their own standard post rates, right? So the faster you can come to a resolution, the less likely that it's going to hurt your pocket, right? So, as I mentioned, I think that car has reasonable prices. I believe it's like $500 each party that they pay, and I think it's a 2 hour. Most situations can be knocked out in 2 hours. I was one mediation out in Anaheim about a year, 2 years ago, and it was at the PWR office, and they put it was agent to agent dispute, and the mediator was really dialed in. He understood the history, and he just kept pressing both of them because it was a dispute. One agent believed that that was her client, that she didn't have to pay the partnership any money. They were already broken up, and she was getting a substantial amount. So the agreement was 60-40, and she didn't want to pay anything to her partner at the time. So as the broker, I did not want to be involved in it because they're both my agents, and I'm not going to side for one or the other. I'm very neutral. So I told both of the agents, that says, in order for us to kind of help navigate it, let me get myself out of this because I believe there's a conflict of interest. I like you both. I don't want to make a decision. It's not my job or duty. You guys got to figure it out. Let's escalate it to a mediator that will be neutral, doesn't know you, doesn't have a relationship with you, and it's matter of factual information. And they agreed, and we came to an agreement. So realtors' participation and broker issues. A common misconception among agents and brokers regarding the mediation clause automatically binds everyone involved in the transaction. All right, when are brokers required to participate? A listing agreement dispute. When compensation dispute arises between a seller and a listing broker, the listing agreement itself generally contains its own mediation requirements. In those cases, the broker is directly bound to attend mediation before pursuing any other remedies. The purchase agreement, right, binds the buyer and the seller to mediate. Brokers are only drawn into the process if they voluntarily agree to participate. Brokers are not automatically compelled by the RPA to participate in the buyer-seller dispute. Remember, these are disputes between them. If you can avoid yourself entangling yourself in that, then it's perfectly fine. Okay, you don't have to, but let leadership know so that way we know what's happening as well. Why this matters, right? Agents often incorrectly assume that the broker will be forced into buyer-seller mediation. The assumption can lead to poor decisions, either exposing the brokerage unnecessarily or missing an opportunity for early resolutions. Before a broker participates, broker level consultations is essential. Risk management reviews and recommends, and legal review should be considered for significant disputes. Once a broker participates, statements, documents, and admissions all become part of the record. All right, so common disputes that lead to mediation. Okay, so these are some of the common things that I see quite often. Deposit dispute. Number one, cancellation disagreement, liquidated damage, contingency timelines. Disclosure claims, roof leaks, permits, foundation issues, neighborhood conditions. Failure to perform, contingency delays, notice to perform, finance delays. Repair disputes, scope disagreements, unclear expectations, credit versus work. Compensation disputes, BRBC agreements, referral agreements, and procuring cause are some of the most likelihood that we see these situations going to a mediation. So be mindful and understand your position. The pattern behind most lawsuits. The majority of real estate lawsuits are not the result of fraud or intentional wrongdoing. They are a predicted outcome of a breakdown in communications and documentations, expectations, and management. So true. Part of it is emotional escalation. Part of it is poor communications, lack of communication, unmanaged expectations. So if you can navigate and avoid any of these four items, then I can promise you that your resolution will be a lot easier and faster, and you're not going to be entrenched in a particular mediation or even a lawsuit. So again, be very mindful in your position as you're navigating these very sensitive conversations as well. Agent conduct during a conflict, right? The moment a conflict begins, the most dangerous thing an agent can do is react the way their clients react. And this happens. I've seen, and I kid you not, and I'm putting this to notice and record, is that I've seen where agents get into arguments and fights with their clients, and they're cussing each other out. You know, conduct yourself as a professional at all times. Okay, be the bigger person. Okay, because remember, you're a licensed professional. Act like it. And now especially with social media, right? You don't want to be the Karen, okay, of a situation that now it's on social media and you're blasted, and now you go viral. Be careful. All right, professional communication under pressure, right? Poor communication. All right. Whereas professional communications, right? So I'll just kind of let you read it, but your seller is absolutely killing the deal, and my client is done playing games. We have documentation of everything. You'll regret this. My client is going to sue, and they will win. These statements are inflammatory, make legal conclusions, and will be used against you, right? And instead, more professional communication. Buyer remains interested in finding a path towards closing and is committed to resolving outstanding concerns throughout the appropriate channels. I want to make sure we have a clear record of the timelines, and I will follow up in writing to confirm. See how the dynamics changes from barking and escalating something that could have been stopped. Now you just put more fuel on the fire, and now you got everyone upset. Broker protection, non-negotiable rules, right? Document timelines immediately, right? Document, right? Confirm conversations in writing. Anything that you say sometimes is not relevant because it's not going to hold water, right? So you want to make sure that moving forward, we'll talk, but we need to have something in writing, right? So most agents will say, look, all communication stop. Now we're just going to communicate via email. So it documents the conversation. I know it's a little bit more tedious, but it's necessary so that way you know where you stand if this goes sideways. And more so, you can't remember what you do or say, but you will remember what you put in writing. Okay. Avoid legal conclusions and escalate serious issues early, right? So pretty common sense stuff. Case studies and discussions. Solar misrepresentation. MLS lists the property as owned solar. After closing, the buyer receives lease assumption paperwork, discuss disclosures, exposure, MLS accuracy, obligations, and mediation risk for listing agent and seller. Yeah, so be very mindful and be careful what you put on the MLS. Double check, triple check, quadruple check if you need to make sure that the seller's telling you if it is own or if it's still leased, because the new buyer, and we're dealing with a lawsuit right now because solar panels. Okay, the seller says, oh, they're paid off. Buyer closes the deal, and Tesla Solar reaches and says, hey, you need to sign this agreement, and this is what's going to cost you like $30,000-$40,000. I don't know where the communication broke, but obviously that's a big issue. Contingency disputes. Seller issues a notice to perform. Buyer alleges that the seller obstructed their ability to perform. Discussion timelines, documentation, good faith, obligation, and which party conducted the trigger mediation, right? And then the last, compensation. Buyer claims they never agreed to pay the buyer broker compensation. Broker produced a signed BRBC agreement, enforceable whether the mediation required applies, and critical role of documentation. Again, as I told you earlier on the scenario, it's vital and important that you document everything. All right, so the final takeaways. Mediation reduces financial and emotional damage. Mediation clause carries major attorney fee consequences. Agents must never practice law, and most disputes are preventable. Okay. And then close out thought. The strongest agents are not the most aggressive agents. They are the agents who can stay composed while everyone else loses control. Professionalism during a conflict is one of the most powerful competitive advantage available to a California real estate professional. Master it, and you protect your clients, your license, your brokerage, and your reputation at all times. And that concludes our class. A lot of stuff, right? All right, let's see if we have any chats. Mr. Gottlieb says here, anytime we're in a conversation with a client that we feel the transaction might end up in a dispute, at the end of the conversation, send a client an email recap of what was stated in a conversation. Love that. Yep. Yeah. That way, we have everything in writing. And this is something that, the buyer and the seller could say, hey, this is what we talked. This is a recap. I'm just providing what we talked about. That way, there's no misunderstanding and you have it all documented. So thank you, Steve, for stating that. Fred says, I think the small claims went up to 12,500. Okay, I believe so. I'm not 100% sure, but thank you for doing your research on that. And then we pay for attorney's therapy. Yep, 100%. So thanks for the information. I hope this was of value. If you're interested in a copy of this presentation, please send me an email. Again, this is recorded, will be uploaded up to our KW Shares. And with that, I want to wish all of the mothers a wonderful Mother's Day this holiday. Oh, it's not even, well, it is a holiday weekend. So have fun, enjoy your time with your family, and we will see you on the next contract class. Thanks, everyone.
Thank you, Simon.
Thank you so much, Simon.
Yeah, thank you.
Thank you. Have a happy weekend. Bye-bye.
Thank you,
Thank
Simon.
you.
Have a good day.
Thank
You
you.
too.
Happy
Thank you
Mother's
very
Day
much.
to everyone.